Hello.
Hello. It's my pleasure to welcome
Hi.
Jan Fermon. Jan is the Secretary General of the International Association of Democratic Lawyers. He has defended victims of genocide in Rwanda, victims of war crimes committed by US troops in Baghdad, and since the 1990s, he has been defending Kurdish and progressive Turkish activists and organizations against both repression in Turkey and against criminalization in Europe. Jan served as the lead solicitor in a landmark case before the Belgium Court of Cassation, which in January 2020 ruled that the PKK should be classified legally as a party to an armed conflict rather than as a terrorist organization. He will be speaking with us today about what this case means for the efforts to decriminalize the PKK, the possibilities for using this ruling in the campaigns to realize a peace process in Turkey, and the implications this case has for criminalization under the war on terror in general. It's a pleasure and an honor to welcome you here. Thank you.
Thank you for having me.
How do you think the ruling of the Belgium Court of Cassation impacts the possibility of achieving similar rulings for the PKK in other countries or bodies in which the PKK is legally designated a terrorist organization?
Well, first of all, we should of course be not too, I would say, enthusiastic in the sense that this is a Belgian ruling by a Belgian court. And so it of course doesn't have a direct impact on other courts in other countries. But I think there are a few aspects to it that are positive and that allow us to use this decision as a lever in other countries to at least get some discussion. Because the criminalization has been going on for decades now, and almost without any discussion. It seemed to be that it was an obvious matter. I think one of the reasons the decision of the Belgian court might be of help for the discussion in other countries is that it is absolutely in line with international law on the matter. The distinction between terrorism and parties involved in civil wars, in fact, actually after 9/11, it became very difficult to make that distinction in court. Now, I think the Belgian court says, wait a moment, there is a distinction. There is a distinction in international law between these two types of phenomena. And I think it's important to re-emphasize that distinction, because there's a difference between movements fighting with the large support of a party of the population, fighting civil wars against regimes that are oppressing part of the population. There's a distinction between that and organizations that are terrorizing the civil population, as, for example, we have seen Daesh doing in the Middle East. So it's in line with international law. It's in line with reality, because on the ground, these two phenomena are distinct and are different. It challenges the idea, which actually came up with the war on terror, that whatever the state does is right. It reinstores the idea that states might be wrong, and that at some point resistance against state violence might be legitimate. And that anyhow, in that kind of situation, the situation has to be dealt with from a legal point of view differently than when it's just blind criminal action against civilians. So all these points are, I think, in line with reality, in line with the situation on the ground, in line with international law, and in line with what is happening in this precise conflict. So I hope that the fact that the Belgian court, I would say at last, after all these years throughout Europe of decisions which were almost automatical, that the Belgian court has said, wait a minute, let's try to have a deeper look into this. Let's examine what is really going on there. That might be stimulus for other courts to at least open the debate and at least open the question. So from that point of view, I think it can be a powerful lever in other countries when it's well used. Also, and I think that's important to emphasize, is that this, I would say, the legal framework on which this decision is based, sometimes it's presented as a kind of Belgian exotism. It's a typical Belgian situation, which, and so Belgians are always doing strange things, so you shouldn't mind. But actually that is not correct, because the clause on which this is based, which says that anti-terrorism law should not be applied to armed conflicts, to parties in armed conflicts, which are ruled by international humanitarian law, by the laws of war, and not by anti-terrorism law. That provision is not only included in the Belgian law. It's a provision which is actually present in all international treaties on terrorism. All these treaties, which have been adopted largely by countries throughout the world, by the European Union, by the Council of Europe, by many other bodies and instances, all these treaties have this same clause. And up until now, many countries considered it to be a kind of style clause. Actually, it's not important. It's something, it should be there and it's there, but you shouldn't pay attention to it. And actually, the Belgian court now said, no, this is a real provision. This is a real matter. This is a real point of discussion in law. And so this is not a particularly or a specific Belgian approach. The only thing which is specific for Belgium is that the Belgian legislator incorporated it very explicitly in Belgian law. But it's not because it's not incorporated in national law and it's only there in international treaties that it doesn't apply in the international legal order and that it doesn't apply in other countries. So this is not a Belgian exotism. This is a Belgian court applying a provision which is generally adopted and generally accepted in international law, applying it to a concrete situation. And from that point of view also, I think, if you consider it in this way, well, at least it's possible to argue before judges in other countries that because it's a provision of international law, they should also pay attention to it and not just waive it.
Okay, thank you. Now, the Belgian court ruling was a purely judicial decision, not a political one. That is, Belgian political authorities retain their capacity to treat the PKK as a terrorist organization. In your view, what does this mean for the role played by the court ruling in the PKK's broader struggle for decriminalization? How can the Belgian court ruling be used moving forward in this fight?
Well, this question goes to the relations between the executive and the judicial power, of course. And it's a delicate question, because on one hand, we were very happy that in the Belgian legislation, the judicial power is not bound by the opinion of the executive. There are systems in other countries in Europe where organizations are designated as terrorists by the executive power, and then the judge has to apply that designation, which means that he's bound. In our system, I think that's a very positive thing. The judge remains completely independent to consider an organization as being a terrorist organization, yes or no, based on the facts of the file, based on the facts that are submitted, the evidence that is submitted to him or to her. On the other hand, of course, this to some extent allows the Belgian Minister of Foreign Affairs to say in the afternoon when the ruling was published in the morning, to make in the afternoon a statement saying, yeah, but we still consider PKK as being, that we, the political, the executive power, still consider PKK as a terrorist organization. However, I think it does also give us some leeway for also discussion on the political level for a series of reasons. First of all, when a judge makes a decision on the law in a country which is under the rule of law, it is, I would say, normal that the executive then actually applies the law. Of course, the law on everything what is related to prevention of terrorism, listing, blacklisting, etc. It doesn't have exactly the same legal criteria as the criminal definition of terrorist organization. Nevertheless, I think at least the executive, although formally it does have the power to take a decision, a political decision to continue to consider PKK as a terrorist organization, I think nevertheless the executive should pay attention to the opinion of the court and should pay attention to the legal analysis the court made. Two, I think from a political point of view, it would be much more interesting for the executive to seize the opportunity, because it's obvious that there is a conflict going on. It's obvious that Turkey and the PKK are engaged in a conflict. Now, if you approach this situation through the spectrum of anti-terrorist law, then of course you can't try to contribute to conflict resolution. Because if you consider it as terrorism, as criminal activity, then it's not a matter of conflict, then it's a matter of crushing the criminal activity. So I think if European states want to play a positive role, if they want to contribute to conflict resolution in this area, they should probably say to the Turks, listen, our courts consider this now to be a conflict and not a matter of criminal terrorist action. We will take that approach and try to work with you and with the Kurds to help you to solve the conflict. Not to crush the other party, but to solve the conflict and to go to the root causes of this conflict, to find lasting and just peace as a matter of resolution of this conflict. So I think politically, it opens a window of opportunities also for the European government. Unfortunately, until now, they don't seize that opportunity. But if the discussion grows, if judges or judicial bodies in other countries take the same position, then it might be, I would say, a mechanism that can lead also to some political reflection on how can we be useful in solving the conflict instead of crushing one of the parties. The third point is that there was an extensive discussion in the Belgian courts about the so-called evidence that has been used by the British Home Secretary, by the US administration, by the European Council when the PKK was listed as a terrorist organization, by the Council, etc. There was an extensive discussion in the Belgian court about the evidence on which this is based. All these designations are based. And actually, it showed very clearly that a lot of this evidence is actually rubbish. For example, the prosecutor in the Belgian case showed the list of incidents that was used by the European Union to list the PKK as a terrorist organization. We examined that list, and we found on that list a series of incidents which PKK absolutely denied being involved. PKK condemned the action. We found a series of lists of facts or events on which Turkey initially accused PKK. But even Turkish courts then found that the people who were prosecuted for this, that there was no evidence. there are incidents on the list where it's proven now it's false flag incidents, that they were committed not by PKK, but by Turkish security forces. And so this list is going around in Europe, is the basis everywhere for listing, for convictions, for prosecutions, etc. But if you make a serious analysis of this list, you can see that this is, a lot of what is on this list is pure rubbish. And so the important thing there, I think, for also for foreign courts, is that in our case, the Turkish state was actually as a civil party, was present as a civil party. And the Turkish state had the possibility to submit evidence to the court. And we actually even provoked them on this. We said, okay, Turkey is not a failed state. You have police forces, you have intelligence, you conduct criminal investigations, you say that this bomb was launched by PKK. Okay, where is your criminal file? Where is the evidence? Where is the forensic evidence that about the explosive, about the detonation mechanism? Where is the phone taps that show that PKK was involved in this? And actually, the only thing the lawyer of the Turkish state did was look at his shoes. And they didn't bring one single line of evidence. So I think that's also something that should be taken into consideration. A lot of these lists and incidents that are then where PKK is accused of being responsible for the incidents, I think if you look carefully at it, you can see that not only there is no evidence that PKK was anyhow involved in this, but on the contrary, you will sometimes find evidence that the Turkish state was involved in these incidents, that the Turkish state was responsible for these incidents. And I think that's also something we should, in the discussion throughout Europe, we should say loudly and clearly. And the Belgian judge, anyhow, went rather deeply into the examination of this, in the assessment of that kind of materials. And although that was not the main point of discussion, actually rejected the claims of the prosecution that PKK was involved in these. So I think that's also something which we can use as a lever in discussions in other countries to say, okay, please don't just take the list which is going around for 20 years now or 10 years, and which is updated from time to time, but please look at the list and examine it and look into what evidence there is supporting that list of incidents. So I think these are all possible, I would say, results we can grab to try to push forward the discussion throughout Europe.
As you alluded to already, many countries and international entities use a prescription system, whereby an organization is deemed a terrorist organization in a decision made by a political authority. In the Court of Justice of the European Union, a case is currently pending concerning the PKK's continuing inclusion on the European Union's asset freeze list, which is an example of such a prescription system. In your view, what are the prospects for this case being ruled in favor of delisting the PKK? And if such a decision is achieved, in your view, how would this impact the fight for the decriminalization of the PKK moving forward?
Well, first of all, as you know, there is a decision already of the Court of First Instance, which annulled all the inclusions of PKK in the list between 2014, when the case was filed, and 2017. The court found that precisely that famous list, which is which pops up everywhere and which is used by many instances to criminalize PKK as being terrorists, that list was actually not reliable, that it was not sufficient as evidence to say that PKK was involved in terrorist action. The only reason why PKK was not completely removed from the list is because for purely technical reasons, the list which is renewed every 6 months, the last renewal for procedural reasons could not be included in the ruling of the court. So actually the court annulled all the decisions, but was not in a position from procedural point of view to annul the last decision. However, that last decision, 2018, was taken precisely on an identical statement of reasons than all the previous ones. Statement of reasons which the court of the first instance of the European Union found insufficient to put PKK on the list. I think the normal reaction of the political instances of the executive powers on the European level should then have been to say, okay, the court found that this statement of reasons was insufficient. So either you look deeper into the problem and you come up with another statement of reasons, or you delist. Either you find new evidence, which is better, more solid, or you say, okay, the court found this insufficient, so we delist. Actually, the European Union, after 6 months, the last decision was not cancelled, and after 6 months, they took exactly the same decision, based on the same statement of reasons. So, I mean, at least we can say that the Court of Law, European Court of Justice, Court of First Instance of the European Union, found that the evidence provided to show that PKK was involved in terrorist action and which allowed to list PKK from 2014 to 2017 could not be upheld. That decision could not be upheld. That is a decision, a point of view of an independent, actually a panel of judges, because it's not one judge, it's a panel of judges. European Union appealed that decision. So the case is now pending before the European Court of Justice, which is actually the appeal court. I don't know what it's going to. I don't want to make any vision on this, because I think it's dangerous to make any prediction on what the court will decide. We'll see. The only point I think we can at this stage keep in mind is that a panel of learned judges, panel of highly specialized, serious judges found that the reasons why the European Union included PKK in the list in 2014 and kept PKK on the list during that whole period were insufficient. And so, yes, of course, that can contribute also to the discussion, because at least even if the appeal court upholds the decision, at least one can argue that there is some kind of doubt, because a panel of judges found that that evidence was not serious and not solid evidence.
Now, following the ruling from the Belgian court, do you expect either the Turkish state or prosecutors in various contexts will change their strategy at all? For example, do you foresee prosecutors employing different angles of argumentation concerning whether the PKK is a party to an armed conflict or a terrorist organization, or different political avenues the Turkish government may pursue to continue their criminalization of the PKK?
You mean prosecutors in Belgium or in European countries, or prosecutors in Turkey?
Either.
Well, I think Turkey will go on with criminalizing PKK, of course, and not only criminalizing PKK, but criminalizing as PKK any kind of Kurdish-related organization. The Turkish state will never stop that, that's obvious. I mean, they will never stop it. I hope they will stop it one day, and they will at some point go to the negotiation table or return to the negotiation table and negotiate seriously to try to find a lasting peace and a just peace for this conflict. But at this point, it's very clear that certainly this Turkish administration, that's not the mindset of this Turkish administration. I think of course, it's not because we won this battle in the Belgian court that prosecutors throughout Europe will give up just like that. In fact, from that point on that question, I think it's important to underline or to remind how this case was actually created. Kurdish organizations, Kurdish media, the Kurdish National Congress, other organizations are present in Brussels for decades. They've been working for decades. In the 1990s, at the end of the 1990s, beginning of the years 2000, under Turkish pressure, there was a very big, I would say, prosecutorial attack on the Kurdish television, which has its studios near Brussels. That case, for various reasons, completely collapsed in 2003. There was not a general acquittal, but actually the case was dismissed. Then there was an attempt to attack the television through tax legislation. The Kurdish television won the case. I think it was 2005 in the tax court. And so that offensive clearly was stopped. That offensive had no future. Turkey then started putting pressure on the Belgian authorities to start another case against all the other, again against the media, but also against the Kurdish National Congress, etc., and representation in the European Parliament, etc. At the very beginning, the Belgian authorities were very reluctant to do so because the Turkish authorities, the Turkish embassy came up with so-called files, and the Belgian authorities repeatedly said that those files were absolutely empty, that whatever was described in these files was actually matters which were unprotected by the freedom of expression, the freedom of organization, and that there was no crime under Belgian law. The Turks then did what all kids do when they are not, when nobody listens to them, they get their bigger brother. And so that's exactly what they did. And so suddenly the US Embassy got involved. And the US Embassy started to organize meetings with the Belgian judicial authorities, with the Belgian police, with the Turkish representation of the Turkish Embassy. And actually a series of high-ranking US delegations came to Belgium to convince the Belgians to take action against PKK. That's in 2006, 2007, 2008. At the end of 2008, the Belgian minister, through the facilitation of the US Embassy in Brussels, the Belgian Minister of Justice, of Interior, and of Foreign Affairs go to Ankara at the end of 2008. And suddenly, when they come back in 2009, the federal prosecutor starts an investigation. We know all this because all this was published in WikiLeaks. All the cables are on WikiLeaks. And so you can, on WikiLeaks, you can see from minute to minute how the Belgian authorities, in the beginning, very reluctant because they thought that this was not really a good, there was no evidence and that there was no case. Gradually were put under pressure both by the Turks and by the US, and then convinced to take action. And that's how actually this case started. The prosecutor then collected a whole series of small cases. A Kurdish association somewhere in the south of the country had collected money no violence. Kurdish women held a cultural camp somewhere in the east of the country. No violence, no weapons, nothing at all. Songs and culture and etc. But so, all these non-cases, all these cases which actually the police conducted an investigation and then stopped it because there was nothing criminal about it. The federal prosecutor then pulled this all together and said, oh, I have a case. I have a case and I will, and on top of that case is the Kurdish National Congress in Brussels, because they are organizing all this and they are in contact with PKK. So these women in the east of the country, they are PKK. And this guy collecting money for a cultural association in Charleroi, it's PKK. And the representative of the Syrian PYD, PYD is related to PKK, so he's also PKK. And Kurdish television, they show pictures of Öcalan, so they are also PKK. And all this is one big structure. So that's how, from nothing, from absolutely nothing, he built a case, which then became a huge investigation into all these structures with searches and arrests, etc., etc. We even didn't have the chance to discuss all this at the present stage, because in this preliminary stage, the court said, yeah, well, but even if all this is true, nevertheless, it's not evidence that PKK is a terrorist organization, because PKK is involved as a party in an armed conflict. And so terrorism law simply doesn't apply to PKK. And it is allowed, and that's of course the big difference with terrorism, it is allowed to take a position in favor of a party in an armed conflict. That's not a crime. It's not a crime to say that one supports, in the situation of a conflict, one supports politically one of the parties. It's not a crime to say that, to publish the points of view of a party in a conflict. It's not a crime to collect funds for a party in an armed conflict. And of course, and I think rightly, it is not allowed to do so for a terrorist organization. I don't want propaganda for Daesh in Brussels. It's very clear. I don't want people to collect money for Daesh in Brussels. I don't want them to recruit for Daesh, because Daesh is, apart from the fact that they wage war in Syria, but they also terrorize the population throughout the world, which PKK doesn't do. So different situations, different attitudes, different laws should apply, and different consequences should be drawn in relation to how far you can reduce or you can restrict the freedom of expression, the freedom of organization, the freedom of action in relation to one type or to the other type of movement.
So the struggle for decriminalization requires many spheres of activity, including legal battles, political pressure, and popular mobilization. So what kind of activities beyond the courtroom do you consider most essential now in the PKK's fight for decriminalization? What are some ways you think the Belgian ruling could be incorporated into these activities, such as applying pressure to institutions or mobilizing awareness-raising campaigns?
Well, as I said in the beginning of this interview, I think one of the important points of the Belgian ruling is that it reminds of the fact that there is a conflict ongoing, and it opens a political perspective to act as a state or as a country or as a body, an international body, to try to help to solve that conflict. And I think the Belgian court somehow, how to say, opens a discussion, questions something that has been considered throughout Europe as obvious for years. The There was no discussion about the nature of PKK. The Belgian court actually opens a window there. And of course, that's very important, not only for the legal discussion, but also for the political discussion, for the advocacy work, I think, for example, talking to members of parliament, talking to trade unions, talking to mass movements. It's much easier if you can say, listen, a court of law in a country which is under the rule of law, which is not a kangaroo court, actually examined the question and found that this should be approached in a different way. This should not be approached through just blind criminalization. They found the evidence that PKK is a terrorist not convincing. They found the evidence that it's not a matter of blind violence, but it's a matter of a conflict between two parties, one state and one non-state party. They found that evidence convincing, and it gives you the opportunity to take a different position. It gives you the opportunity to play a positive instead of a negative role. Of course, this can be a very powerful argument in all these types of work. At the same time, I think it's only the combination of all these types of work that can finally provoke a shift in the policies. This reminds me very much. I have an age where I'm remembering. I know something about the struggle against the apartheid in South Africa. The apartheid regime was very close to NATO, and so in many European countries, for all kinds of reasons, there was political solidarity with the apartheid regime. ANC, the African National Congress, was criminalized as a terrorist organization in some countries which had a terrorist, anti-terrorist legislation at that time. Nelson Mandela is, by the way, still on one of the US anti-terrorist lists, I think. They forgot him on the list. So actually then apartheid finally fell down, because more and more there was legal that, there was a broad movement in public opinion, there was a boycott. The apartheid regime was also had military defeats in Angola and in Mozambique. And it's of course the combination of all these different, the internal struggle, the international support, the international solidarity, the boycott actions, the legal challenges, it's all this together which finally led to the disappearance of the apartheid regime. Now, I think the Kurdish struggle is, there are many similarities. The Kurds will have to continue their work in the European Parliament. They will have to, I think, intensify their work in the public opinion in Europe. They will have to intensify their work with trade unions, with MPs, with large women's organizations, with the progressive and solidarity movement. But I think a legal decision like this, which shows that it's not a revolutionary act to look at the problem from a different point of view, that even a conservative court of law can open that window and can have a different approach, should facilitate certainly the discussion with many people who are either afraid to stick their neck out and to accept that there is a discussion possible, or who are convinced or are just following blindly the policies that have been conducted for such a long time.
Beyond what you just said concerning the next steps in the fight to decriminalize the PKK, are there other kinds of cases or legal challenges you hope to see brought forth? What of the possibility of seeking to charge Turkish military officials with war crimes on the basis of the Belgian court ruling designating the PKK as a party to an armed conflict subject to the Geneva Convention?
Well, actually, you don't need the Belgian decision to do that. I think, of course, prosecuting war crimes is a complicated matter because, as such, war crimes are well defined under international law. But then there's the forum problem. Of course, you can't go to a Turkish court and say, we demand you to prosecute Turkish military for war crimes, because I don't think that's going to be successful. The International Criminal Court has no jurisdiction because Turkey did not ratify the Rome Statute. And so if Turkey doesn't ratify the Rome Statute, the International Criminal Court doesn't have any power over the situation. So they can't prosecute or indict Turkish military. There are some possibilities in Europe, sometimes under the so-called universal jurisdiction, which means that countries actually gave themselves the power to prosecute war crimes wherever committed wherever in the world. But that is very rare. And it becomes more and more rare, universal jurisdiction. But sometimes there are opportunities. I would say the fact that some of the high-ranking Turkish military leaders now sometimes themselves are under prosecution or are abroad because they were with the Gulen movement, maybe give some opportunities to launch some investigations. But I don't think that, neither from a legal point of view nor from a political point of view, that on this specific point the Belgian decision is really very important, because prosecuting for war crimes, you can do it also without this decision. And of course, war crimes have been committed, especially in the conflict in 2015, 2016. But precisely because of the absence of a forum, of a possibility to submit this to a court of law, a court of opinion, a session of the Permanent People's Tribunal, which is a court of opinion set up by leading intellectuals from different countries, was held in 2017, I think, 2017, 18 in Paris. And that court of opinion found that obviously war crimes were committed. But it's a court of opinion.
As you mentioned earlier, a primary goal of the PKK is to engage the Turkish state in a peace process to achieve a political resolution of the conflict. In your view, does the legal designation of the PKK as a party to are engaged in armed conflicts rather than a terrorist organization mark a significant step towards achieving a peace process? What are your thoughts on how the Belgian court ruling could be used to campaign for a peace process?
Well, I think that's very simple. Terrorism, you fight it, you crush it, you stop it by all possible means, because it's necessary. It's a threat to the peace, it's a threat to the people, it's a threat to... So if you're confronted with terrorist criminality, then you have to, your duty as a state, not only the Turkish state, but also the international community, the states on an international level, they have to support the country that is fighting terrorism. If a country has a conflict, is involved in a conflict, the country itself will always pretend it's criminality. There's no, Turkey will, the French, when they were fighting against the Algerian National Liberation Army, they of course said it's terrorism and it's criminality, and they didn't admit that there was a conflict until the very end when they went to the negotiation table. The apartheid regime in South Africa during the apartheid said the ANC, the African National Congress, is a terrorist organization, and Nelson Mandela is a terrorist. Until the very end of the conflict, when they also were brought to the point where they understood that there was no other solution than to negotiate. So the states directly involved in the conflict, I mean, they will only at the very last stage change their minds. But the international community is a completely different matter. The international community, instead of saying to the Turkish state, we are with you to crush PKK, which is actually the point of view of criminalization and the fight against terrorism. If the international community says to the Turks, well, you have a problem. You have a conflict going on your territory, and we can help you to try to solve it. We can offer you our good services to mediate, to help you find a solution, to facilitate negotiations, etc. Of course, that could have a very important influence. So I think the only perspective for a political solution, the only perspective for a negotiated solution, is precisely in the approach of this whole situation as a conflict and not as criminality. Because if you approach it as criminality, there is no space at all for negotiation, for mediation, for conflict solution. You don't negotiate with criminals, but you negotiate with an opponent in a conflict, because that's the only way out of a conflict. That's the only way you can get out of the conflict. So I think it's very clear that this approach by the Belgian court is the only one that can open a window on for the international community, for the international approach, can open a window on a perspective of helping a peace process getting on the rails.
Now, following on from this last question, Abdullah Öcalan, the imprisoned leader of the Kurdish freedom movement, is considered a central figure for any peace process, as evidenced by the short-lived talks for peace negotiations from 2012 to 2015. How do you think the Belgian court ruling could impact the campaign for Abdullah Öcalan's freedom?
Well, actually, in the same way as on the previous, I would answer in the same way as the previous question. Abdullah Öcalan will only be released if either he capitulates, which I think he won't, or if at some point the Turkish authorities are brought to the point by the international community and by the internal situation that they understand that the only way out is to negotiate and to find a compromise, to put an end to this conflict. So to the extent that the court ruling offers an opportunity to stimulate the countries to participate in seeking a negotiated or promoting a negotiated solution, I think in the same way it contributes to the question of the liberation of Abdullah Öcalan.
What kind of possibilities do you see for other organizations considered to be terrorist organizations to use the Belgian ruling to wage their own legal battles against this designation?
Well, it depends on the organization, of course. But I think, for example, in relation to Palestine, it's very clear that there is a discussion. It's also a conflict. It's a long-lasting conflict where Palestinian organizations are involved in as a party in a conflict with the Israeli state, and so I think the same principles should apply. That doesn't mean neither for PKK, neither for the Palestinians, neither for that there is impunity, because the prosecutor said, yeah, but if you apply international humanitarian law, that means impunity, which is of course not true. When an organization, whatever, involved in a conflict commits violations of international humanitarian law, war crimes, crimes against humanity, etc., that organization can be held accountable without any problem. So it's not a matter of impunity, but it gives a different approach. And so again, Palestine, and without any doubt, other situations in the world could be analyzed in a different perspective if they were considered in line with international law as a conflict situation and not as a matter of criminal activity. So yes, I think it opens a window also in the more broader discussion on anti-terrorism policies and legislation, and when it applies and when it doesn't apply.
A final, more general question. Under the banner of the global war on terror, we've seen a tendency towards criminalization of all non-state actors engaged in conflict or physical struggle of any kind. Often when this actor is considered by a people to be their political representative, they too are criminalized, as is the case with the PKK. This trend seems to be expanding to include more kinds of organizations. For example, in the UK, we've seen groups like Extinction Rebellion classified as extremist under the Prevent Protocol, and President Trump recently announced intentions to classify Antifa as a terrorist organization. How do you see this trend of prescription and criminalization developing in the future? And furthermore, the Belgian court ruling offers the possibility of new legal status and legitimacy for the PKK as a non-state actor engaged in armed conflict rather than a terrorist organization. What sort of impact do you think the Belgian court ruling could have for efforts to resist criminalization from the war on terror regime in general?
Well, first of all, I think we have to go back a little bit in time. The anti-terrorist policies and legislation, which was created, I would say, in most parts of the world after the events, the 9/11 events. Actually, that policy broke away from, I would say, rules and positions and some gains in international law resulted from the Second World War. Before the Second World War, actually, especially in fascist countries, any kind of opposition to the state, of whatever nature, was considered to be criminal action and terrorists. As you know, any kind of resistance against the Nazi occupation was dealt with by the Nazis as criminal and terrorist activity. So the paradigm at that time was the state is right, the state has the monopoly of what is right, and so anybody who is opposed to the state is by definition involved in a criminal activity. Of course, at the end of the Second World War, with Paris being liberated by those terrorists, the Balkan being liberated by the terrorists, many other places in Europe being and throughout the world being liberated by those terrorists, it was rather difficult to maintain that line of reasoning. And that's why in the preamble of the Universal Declaration of Human Rights, and later also in other international legal instruments, there was actually a double evolution. First of all, the potential legitimacy of rebellion against tyranny was recognized as a legitimate action in the preamble of the Universal Declaration of Human Rights. And at the same time, in the Geneva Conventions, which actually ruled, which rule the situations of war, which determine the applicable legal framework in situations of war, gradually non-state actors were given some kind of legitimacy. For example, the second protocol to the Geneva Conventions is actually about internal conflicts. It's about non-international armed conflicts. And so I think that is the logical result of, first of all, the anti-fascist resistance, and secondly, also of the anti-colonial movement, because they're also so-called terrorist organizations suddenly became states. Algeria. The anti-terrorist legislation actually breaks away from that and tries to go back to the pre-war situation, where any kind of resistance against state action is by definition criminal and terrorist. And so, and the anti-terrorist, I would say, actions went very, very far in this, criminalizing everything. Some countries saying that the monopoly of the state on the use of force is absolute, which means that it's never legitimate for, not even for the, it's very strange, because actually if you say that, it means that by saying so, the countries who take this position delegitimize the resistance and the Nazis, because that was anti-state violence, that was use of force by non-state actors. So there is a whole process going on where actually a series of states want to get back to the pre-war situation. And you can see it very clearly in states like Turkey, for example, but also in the Philippines. Now you can see that tendency also in an enhanced way in the US, with indeed the proposal or the position of Trump saying that Antifa should be classified as a terrorist organization. Where this will go, I don't know. I know where I hope it will go. I think, of course, organizations like Daesh, who do constitute a real threat to the security and the safety of the people and to terrorize people. Of course, there is no discussion that this kind of organization and its action should be fought. But anti-terrorism law should, which is actually a special form of general criminal law, because a terrorist murder is basically a murder for specific reasons, but it's basically a murder. So yeah, I'm very much in favor of dealing with all this under criminal law when it's criminal activity, and I'm very much in favor also of dealing with Daesh on the war crimes and the crimes against humanity and the genocidal acts committed by Daesh on the basis of international humanitarian law. But I think it's very important to keep the door open that was opened by the resistance, by the anti-colonial movement, saying resistance against tyranny can be legitimate. And so the law should be construed in such a way that that opportunity, that possibility is still there. And that's precisely what the Belgian court did, to make a distinction and to say, okay, we're not going to prosecute these people under the anti-terrorist legislation because we don't think it applies to them. They are a non-state actor involved in a conflict with the state. They don't spread violence throughout Europe or in other parts of the world. PKK doesn't blow up metros or airports in other parts of the world. So you have to deal with the conflict under international humanitarian law. If they commit war crimes or crimes against humanity, you should prosecute them for that. But that also implies that if the Turkish state commits war crimes or commits crimes against humanity, you should also prosecute them for that. In anti-terrorism law, the balance is completely different. What the state does is granted complete impunity. What the non-state actor does, because it's right by definition, what the non-state actor does is wrong by definition and criminal by definition. that's a completely distorted view. So I think, yeah, from that point of view, it's important to protect the heritage of the anti-fascist resistance and of the anti-colonial movement.
Thank you. Are there any final thoughts you'd like to offer in closing?
No, I only hope that what I really expect, what I hope is that this will trigger a discussion, and that what was considered to be obvious for all these years, that intelligent people, people with some critical minds will accept to look at it again, to take a closer look at what was done, what has been said. And I'm sure that if they do so, they will come to a different conclusion like the Belgian court.
Well, I share your hope. Thank you very much for agreeing to speak with us today.
Thank you for having me.